Hey, everybody. Welcome to the Kathleen Scott podcast. Thanks for tuning in. We're talking today about Charlie Kirk and some of the cases that are filtering through the court system. And specifically, what I'm referring to is employees who made comments about Charlie Kirk's murder and how they are faring in the court system. So many people were terminated, a lot of them teachers and public employees, and these cases are kind of coming out. So I thought it might be interesting to talk about those. One that's here in Florida, just settled, and that's a case involving Brittany Brown. And so she sued the Florida Fish and Wildlife Conservation Commissioner, Mr. Young. And in that case, she had made a comment on her social media following the death of Charlie Kirk. And I'm going to read you the exact quote because I think it's important to be specific here. She was a marine biologist, and the quote is this: "The whales are deeply saddened to learn of the shooting of Charlie Kirk. Ha ha, just kidding. They care exactly as much as Charlie Kirk cared about children being shot in their classrooms, which is to say, not at all." That comment sparked a lot of controversy, and she was terminated. So the case has been going on for a little while and just recently resolved. Ms. Brown received $485,000 as part of the settlement. Of that money, $210,000 went to attorney's fees and cost. The remaining $275,000 went to her for her back wages for losing her job, as well as compensatory damages. In the broader context, what the Brown case represents is sort of a pattern of public employees acting in their personal capacity, making comments on their social media, and then feeling some retribution from that. So let me just pause there before I get too in the weeds on public employee cases and say this. In the state of Florida, private employees have no First Amendment rights. So you can 100% be terminated for comments that you make on social media. So these cases are brought by public employees for a reason, because public employees have a right to First Amendment speech if certain criteria is met. Essentially, what courts do is they balance. They have a balancing test. They balance the free speech and those rights that an employee has to free speech with an interest that the employer would have for something called operation, efficiency, and disruption. So speech has to be classified. Is it part of the job? Or is it private? And that's really the first in the flow chart of whether a public employee has these rights. Step one is, what are they talking about? And are they talking about it as part of their job, or they're talking about it as their private person? If private speech is protected, if it's a matter of public concern, that's the threshold. That's the test. And so here, Brown was terminated, argued her speech was protected and should not have been terminated. It's important to note that in the deposition testimony that was presented and filed in the record, which I did review, the reason that they asked the employer, what was the reason she was terminated? And the sole reason she was terminated was this comment related to whales. So there isn't any dispute that that's what motivated the termination of her case. So what are the arguments? So the argument that Brown made is that she's a private citizen. She's speaking for herself. She's posting on her social media. This has nothing to do with her job, and that therefore she should have a constitutional right to make those comments under this burden shifting test. So what does the employer say? The employer says, no, that kind of speech is completely disruptive. And they're saying it was causing issues, and that's the reason why she had to be terminated. Now, here's where it gets really interesting in this particular case. The agency said that there was, quote, widespread complaints, and that it was causing them operational disruption. And now we know a little bit more. So the case went through what's called the discovery phase, which is where people give depositions and documents are exchanged. And during discovery, it turns out that those widespread operational disruptions were really widespread falsities. And so none of them are really documented. And so when the case really got, put under a microscope and looking at these facts, turns out the defense really wasn't there at all. And the employer could not really substantiate this operational disruption. It gets even more interesting. So this case was actually pending in the Northern District of Florida in a federal court before Judge Walker. And in that case, the plaintiff, Ms. Brown, her lawyers filed a motion for sanctions claiming that these sworn declarations that were filed by the employer contained falsehoods. And the judge agreed. And the judge two judges agreed. Initially, the magistrate who looked at the issue agreed, and then his recommendations were accepted by Judge Mark Walker, who basically said that paragraphs 4 and 5 in one of the employer's submitted affidavits that was sworn were proven during her testimony to contain complete false information. The court heavily criticized the defense team for refusing to admit its errors, and once they were discovered during the discovery process, instead of acknowledging that, they doubled down and they used euphemisms to try to deny that they were in fact false, calling them source defects or overstatements or effective evidentiary weaknesses. Judge Walker flatly rejected this shenanigans, for lack of a better word, and I quote the judge in what he said. There's a label for what Ms. Tucker did, that's the person who made the statement, making false statements, and there's a label for what defense counsel has done, and that is vexatious litigation. That's a mouthful, right? So there's a rule in federal court where you can't do anything that would vex the litigation or make it more cumbersome or more expensive, and that's exactly what the court found that happened here. So that's the argument. And so the case settled soon after that finding. Pretty significant finding to have sanctions issued against both counsel and the person who filed a federal statement. And it was found to be portions of it were found to be untrue. So that's kind of how this case trickled down. But this case is not alone. And there's a lot of these cases looking at this broader concepts and passes, and they often involve teachers. So the one we just went through was a public employee who worked for the Florida Wildlife Commission. There are cases involving kindergarten through 12 teachers, but it's very interesting, isn't it, that a teacher can make these comments and then be held accountable for them, even though they're made in their personal lives. And so that raises that question. And so I just want to caution everyone out there who's a public employee just to be careful about the rights that you think you have. They're not unfettered. You do have a right to free speech if you're acting in a private capacity, but please know that that's not going to save you from being terminated. You're going to have to litigate the issue about whether or not your speech was a matter of public concern, and that is what the law requires in order to do that balancing test. So just to kind of sum up, if you're a private employee and you're engaging in free speech on social media or in your private life, you have very limited protections. Unless you're it's sort of a reversal, so it's confusing. So I really want to break it down. Private employee can talk on social media about pretty much anything they want to, but if their employer doesn't like it and decides to terminate them for that, they most likely will not have a claim. One exception. Maybe there's another one, but the one that comes to mind is this. If you're talking about your job and you're saying things are bad at my work and you're talking about the terms and conditions of employment and you're a non-managerial employee, that is the one narrow situation where a private employee may have rights, and that's called concerted protected activity. But the takeaway is if you work for a private employer, your rights are much more limited than if you work for a public employer. If you work for a public employer, can you make comments that don't relate to your job? It's sort of the opposite. That don't relate to your job? Yes, you can, about matters of public importance. And that's going to be balanced with the employer's right to maintain a workplace and you're not being operationally disruptive. So it's a balancing test. There's no bright line rule here. So I would tread lightly. So while you do have a public right and a First Amendment right as a public employee to engage in free speech, it is not unfettered, which means it's going to be subject to a balancing test. And being terminated may not be your goal, so just weigh that out. It's probably better to have a job than to have a lawsuit claim, so I'll leave that to your own calculus. If you're suffering from some type of adverse employment action, you should contact an attorney to find out your rights. I'm Kathleen Scott, and this has been the Kathleen Scott Podcast. Thank you so much for tuning in, and as always, if you have questions or comments, we're here for them, and we'll see you next time. If you like us, please subscribe below. Take care.